Good afternoon. My name is Gemma and I've been asked to appear before the Parliamentary Justice Committee to discuss the use and availability of special measures for defendants in criminal trials. Firstly, I'll provide a brief overview of the current laws surrounding special measures before delving deeper into 3 reasons why special measures for defendants are important. It is also important to note that current special measures are reserved most commonly for the use of non-defendant witnesses only. 3 arguments I will put to you are that special measures are fundamentally flawed for defendant use, since they were created with the thought of non-defendant witnesses in mind only. This means that in practice they are unfit for purpose. Secondly, as we will see, there are many vulnerable defendants in our criminal justice system, and special measures are vital in protecting and supporting these defendants who suffer with learning difficulties, behavioural disorders, and mental inabilities, etc. Finally, special measures are vital in upholding the Article 6 right to a fair trial within the Human Rights Act 1998. Throughout this presentation, I will draw upon the principles of evidence and discuss how special measures for defendants will uphold and reinforce the principles of evidence that our criminal justice system relies upon. Unfortunately, many people do wrongfully assume that defendants should not be afforded special measures since they think it gives them an unfair advantage in the courtroom. However, I'm here to rebut that myth and show you why they are indeed necessary. The current law surrounding special measures is found within the Youth Justice and Criminal Evidence Act of 1999, and there are currently 8 special measures available. However, as mentioned, they are reserved mostly for non-defendant witness use. These are screens, live-link, evidence in private, removal of wigs and gowns, video recorded evidence, video recorded cross-examination and re-examination, intermediaries, and aids to communication. One reason that these special measures are unsuitable for defendants is because they were created with the sole purpose of aiding non-defendant witnesses in attending court and encouraging them to attend court, give their best evidence and participate in proceedings. However, since defendants are obliged to attend court, a lot of them are impractical for defendants since they centre around being in the courtroom, which the defendant already is. Special measures for defendants are important in ensuring the equality of arms, since defendants are already at an unfair advantage since it is them versus the entire courtroom, and special measures will mean that they have a more equal chance at defending themselves against the court. Moving on to my first argument, that special measures for defendants are unsuitable. The special measures that we have that are actually available to defendants are as follows. The removal of wigs and gowns, communication aids, screens, links, and the use of intermediaries has been discussed in case law but has not yet been implemented in statute. I will demonstrate now why these special measures are impractical. Screens are impractical because should the defendant sit through the entire court proceeding without being screened from the rest of the courtroom, and then as soon as they are required to give their evidence, ask to be screened from the courtroom, the jurors might make adverse inferences from this and assume that the defendant does not want to be seen because he or she does not take accountability for what they have done, and it could be a sign of guilt. However, we know this is not always the case, as mentioned earlier. Many defendants struggle with learning disabilities, behavioural disorders, and other issues. And this could be a genuine reason as to why they feel they need to be screened. In terms of live link is most commonly used when the witness does not want to attend court and feels anxious about attending court. However, as we have mentioned, defendants are obliged to attend court anyway, so this makes no sense for them because they will already be in that location. In terms of reforming this part of the law to make special measures for defendants more suitable in practice, reform and amendment to the legislation is required. It could be introduced that defendants are not obliged to attend court physically and personally, and instead they could attend via live link, whether that be from a different room in the courthouse, from prison, or from a police station. This might make it easier for defendants to give their best evidence and protect themselves. Further, defendants could be able to give evidence in private. Again, this could mean going to a different room in the courthouse and then rejoining afterwards they've given their evidence. Also, although intermediaries has been discussed but not yet implemented, intermediaries being used is recommended, and I think this would be important, as if the defendants are struggling with anything being said or done in the courtroom, they can confide in their intermediary and it will make a lot more sense to them. Moving on, as mentioned earlier, special measures for defendants are important where they are vulnerable. And many defendants, as we know, are incredibly vulnerable and suffer with learning difficulties and different issues. 80 to 9% of defendants have communication disorders, which means they might not be able to understand all the complicated legal terminology that is used in the courtroom, and also they might not understand discussions and what is being asked of them if they are being cross-examined. This relates back to the use of intermediaries, where this could be useful to help the defendant understand what is happening. Also, 12% of defendants are diagnosed as autistic, and therefore special measures would be required to help them and support them during the trial. It is unfair that non-defendant witnesses who would experience these exact same issues would be offered special measures, yet just because the person is a defendant means they do not deserve these special measures. This is unfair and undermines the principles of evidence, as it impugns accurate fact-finding and protection of the innocent from conviction, as the defendant cannot adequately defend themselves and prove their innocence. If a defendant has issues such as learning difficulties, they may feel they are placed under extra stress and again cannot adequately protect themselves. Reform in this area of law is also important, since then special measures for defendants who are vulnerable could be a part of law, and it could be ordered that any defendant struggling with disabilities will be offered special measures. For example, intermediaries again would be incredibly useful to defendants who struggle in this way, as they can communicate with them and help to understand what is happening in the courtroom. Moving on to my final point, if no special measures are provided where needed, this will undermine the Article 6 right to a fair trial. For example, as mentioned in my previous point, if the defendant is vulnerable and is experiencing stress or anxiety or doesn't understand what's happening in the courtroom, they should be provided special measures. The defendant has a fundamental right to a fair trial and to participate effectively in the trial, and if they do not understand what is happening and cannot effectively participate, their right to a fair trial is being undermined. Further, as many people might argue, defendants should not be offered special measures since they are accused of committing a crime and they do not deserve it, and it will give them an unfair advantage. However, the right to a fair trial assures that the defendant has a privilege against self-incrimination and also has a presumption of innocence. However, if the defendant cannot help themselves to argue their case, their presumption of innocence is undermined and their effective participation is not to a good standard, and therefore they could self-incriminate, which should be protected against Article 6. Therefore, special measures are important to enable them to effectively participate, prove their innocence and fight their own case. To reform this, intermediaries could again be offered, and in Article 6, interpreters can be provided to the defendant if they do not speak the language or understand what's happening, and this could be expanded to include those who do not understand what is happening due to their disabilities. To conclude, I have explained to you why the defendant's use of special measures is necessary, since they are flawed for the defendant's use. They are necessary for the protection of the vulnerable, and it undermines Article 6 that special measures for defendants are not already provided. I've adequately explained why reform is needed in this area and suggested a few reforms to help this area of law.